Well, good morning and good afternoon, depending on where you are on this lovely Tuesday. It's beautiful here in Portland. My name is Mikaylee O'Connor, and I'm a partner and head of the defined contribution practice at NEPC. Since joining the firm, I've had the pleasure of hosting our legal and regulatory webinars, and today's discussion is one that I have been very much looking forward to for quite some time. I could not be more excited to be joined by Lisa Gomez, President of LMG Collaborative Consulting Solutions and former Assistant Secretary of Labor for EBSA. Lisa brings a wealth of unique knowledge, insight, and expertise, and I am very much looking forward to picking her brain over the next 30 to 45 minutes. Just to level set a little bit, we are going to cover broad policy shifts at the Department of Labor, the proposed safe harbor framework on investment selection, how to navigate the changing regulatory environment, and then what can plan sponsors do to make sure that their voices are being heard. Um, I know Lisa is very much ready to take your questions, so please use the Q&A button to submit them throughout the webinar, and we will do our best to address as many questions as we can. If we're not able to get to your question, we'll be sure to follow up afterwards. All right, so let's dive in. Lisa, we are roughly a year and a half into this administration, about 9 months since Daniel Aronowitz was confirmed as the Assistant Secretary of Labor at EBSA. So let's start with big picture, right? What's recent Department of Labor policy shifts do you see as really most consequential for plan sponsors? And how do you expect these shifts to really influence sponsor behavior going forward?
Yes, so thanks so much for having me here. Good afternoon, everyone. Good morning, good afternoon, good night, wherever you're located. So we've seen a lot of policy changes with this administration, which, you see them in every administration. But with this administration in particular, and with Dan Aronowitz coming on in the latter part of last year, we've seen a lot of focus on reducing risk for plan sponsors and fiduciaries, whether it be litigation risk, however one might characterize that litigation risk. This administration has characterized litigation risk and not only litigation itself, but what they characterize as abusive, frivolous litigation by plaintiffs. Also a focus on trying to curb enforcement by the agency, having a more focused approach, looking at how the agency is doing enforcement, how long investigations are taking, what investigators are looking at. So there has been, and coupling all of that with more intentional compliance assistance, trying to answer questions, whether it be direct questions coming in from plan sponsors and fiduciaries, let's say through an advisory opinion request or a request for an opinion letter, or just approaching the agency asking for assistance in how to handle something, or through things like amicus briefs and guidance that might come out, field assistance bulletins, various tools that the department is using to put out what it thinks about different issues, whether it be, again, these broader issues of how to enforce ERISA, either by the agency itself or by individual plaintiffs under the law, or thinking about more substantive issues, what the department thinks about pension risk transfers, what the department thinks about forfeitures, and putting those opinions and positions out there to try to guide things in a way that will be I think at least in this administration's view, helpful to plan sponsors and plan fiduciaries. So there's a big focus on that. And, people can argue about how effective it is, whether it's good, whether it's bad, whether it's necessary, but, certainly a big focus on all of that. I think there's also, we hear constantly, Assistant Secretary Aronowitz talking about ending, regulation by litigation, ending regulation by enforcement, and trying to focus more on having rules that are clear for people to understand what's being followed. It's interesting because the administration itself has been focused on deregulation. So I often wonder, okay, so if we're ending regulation by enforcement and we're ending regulation by litigation, but we don't really want regulation, like what are we doing? But so I think there's some, competing things there. And I think the other things in looking at priorities for the administration, we have seen in some documents that have come out, both in a field assistance bulletin that Assistant Secretary Aronowitz issued earlier this year, where he talked a lot about, again, the department curbing, changing focus on enforcement itself, and focusing less on second guessing plan sponsors and fiduciaries when they make prudence decisions, and instead focusing on kind of the worst of the worst, the criminal activity or violations of duty of loyalty. So how that will all play out in real cases, real enforcement, I think remains to be seen. Also in what the department has talked about with their national enforcement projects, and making some changes to what they are going to focus on, and taking some things off of their national enforcement project list, like employee stock ownership plans, and also saying that they're going to focus less on missing participants, those types of things, and putting cybersecurity and mental health parity more on specifically on that list. So again, I don't want to downplay at all what that means in real day-to-day life, but I think it remains to be seen how much of that is messaging, signaling, and how much we really see in day-to-day changes in how the department approaches these various issues. So, I think those are several things. I know we'll
Yeah.
talk definitely about investments, but it's so many of the same themes between the fiduciary rule, things that seem to never go away. The fiduciary rule, they say it's gone away now, who knows? ESG investing, and but a big focus from the administration on transparency and innovation. So, there's a lot of words, big words, floating around out there, and how they turn into real policy, and seeing like what differences we actually see, I think is something to keep an eye on.
Yeah, absolutely. There's definitely a lot that could have a pretty big influence on kind of how plan sponsors operate or the focus areas. So, but to your point, let's wait and see what really happens.
Mm-hmm.
Well, we can't have a, legal and regulatory webinar today without touching on the DOL's proposed safe harbor framework for investment selection. And, um, there's been a number of papers and webinars that have really dove into the specifics, and I don't think that's really our goal today, but I do want to level set just with a quick overview, and then we can dive into kind of some of your views and implications of this proposed rule. So, this was prompted by an executive order encouraging access to alternative investments. And um, that being said, the department's proposal is asset neutral, right? Meaning that ERISA's duty of prudence applies equally across all investment options, remains process driven and not outcome kind of based or oriented. And as part of that, the Department of Labor outlined I'd say a non-exhaustive set of 6 evaluation factors, right? Along with some case studies illustrating what a prudent process could look like. And these factors include performance, fees, liquidity, valuation, benchmarking, and complexity. Now, these are all factors that we at NEPC already focus on as part of our research process. So there's a bit of a business as usual for us. Um, but once the rule is finalized, I would suggest or anticipate that we see some adjustments to policy statements, meeting minutes, and potentially even some reporting just to align better with what the safe harbor outlines. Um, Fittingly, right? We're having this conversation just one day after the comment period officially closed. And so, Lisa, as former regulator, you have a really unique perspective on that rulemaking process. And so, can you walk us through some of the key steps from here? What should we expect between now and the final rule being published?
Yeah. So interesting timing. I'm sure that everyone is still recovering from being up hitting submit at,
Right.
11:59 last night. But how the whole process works, and I was checking, and it looks like they came in at just under 45,000 comments at the end of the day. So what the process looks like, I joke about that we need to bring back Schoolhouse Rock, and how anything works on how a bill becomes a law. And there was never one that I can remember on how proposals and all of these things become a reg. But maybe we should be bringing that back. So I learned a lot when I was in my position at the Department of Labor, because, quite frankly, I had been more of a bystander, like watching what was happening rather than being involved in the process. There were certainly lots and lots of law firms and lobbying firms and associations and different stakeholders that are very involved in this process, pretty much no matter what the regulation is that's coming out. But just going back a little bit to how we got to this point, as you mentioned, we had this executive order that came out last August on democratizing access to investment in alternatives, or exactly what the title was. And so when you're going into the regulatory process, sometimes what happens is that there is a new law that's passed, and you need regulations to actually implement the law. Or sometimes there are issues that come up with existing laws, where you need regulations to implement, to interpret, to give people guidance on how to comply with those laws. And sometimes it comes up, as it did in this situation, where the administration puts out an executive order and directs an agency to provide guidance. Sometimes it will be directly the administration saying we want a regulation. Sometimes there's some more flexibility to the agency about how to address whatever the issue is that the administration is talking about in the executive order. But here in August of last year, there was an executive order that came out that was very much directed at alternative investments, crypto, some lifetime income products, and also in the process of talking about those specific issues, talking about the broader issue of litigation and, trying to curb abusive litigation, protect plan sponsors. So the directive that was given to the Department of Labor was essentially come out with something that addresses this substantive issue, but keeps all of these other considerations in mind. And the department came out pretty quickly in saying that they were going to issue a proposed regulation in response to that executive order. And I think there were a lot of questions about what that proposed rule would look like, because, again, the executive order was very much focused on a certain type of investments. So, what that would look like no one really knew. I mean, what they did come out with, as folks are aware, is a proposal that is asset neutral and that talks about just in general how plan fiduciaries should approach making decisions and selecting the designated investment alternatives. So, which it's kind of an interesting play on words because, investment alternatives are not alternative investments.
Right.
Let's all discuss, or they could be, but it's not limited to that. So gets a little tricky, but the proposal that came out is really just more of a general framework in selecting investments, as a general matter and what fiduciaries should be considering. And you've talked about the 6 standards that they put forward in that proposal. And there are other pieces to it as far as not only what fiduciaries should be looking at in order to satisfy this proposed safe harbor, but what do you get at the end of the day if you satisfy that safe harbor? And the department has proposed a pretty high um, level of what you get if you satisfy it. And, again, like who's deciding if you satisfy it? It's not as if input something into some site somewhere and you get a certificate of compliance
Right.
and you can say, okay, this is wonderful. People are going to question whether you satisfy it. But if you do satisfy it, the department is at least currently saying that you should get a presumption of prudence. And again, what does that mean? What does that mean for courts? Some courts might be heavily swayed by what an agency thinks is prudent. Other courts may, it may not matter as much. So it be interesting to see where this all goes, what those 45, thousand comments say and look like. If you do look at there was a notice and comment period that was put out. As you said, the comment period expired yesterday. And so as of today, you can still submit, you can always send an email to the Department of Labor about whatever you would like, but it's not part of the official comment record, so they're really supposed to be limiting their review now to those comments that have been filed. If you look through the comments, even just, kind of scrolling on your own, you'll see that there are lots and lots of comments that have been filed that are sort of cookie cutter form letter type looking comments, which does not diminish the importance of those comments by any means. They may, vary a little bit from one to each other, but a lot of them are either I love crypto, I hate crypto, the rule is the best thing ever, the rule is the worst thing ever, so a lot of like public opinion and putting those views forward about the rule itself, which again are they're instructive and helpful to see, if you see at the end of the day that 20,000 people took their
Right.
time to submit comments thinking that this is horrible, it's something that, the department I think should take seriously. But I think what the department will be mainly focused on now is taking all of those comments that came in, trying to put them into different buckets, which are for, which are against, which are comments that are kind of, in the middle, which are comments that are specifically on certain of the standards and how those standards should be improved, like where they all fall, what the subject matters are, and then really just coming up with a plan internally at the department of how are we going to address all of these comments because they are required from an Administrative Procedures Act law, perspective to review and consider all of those comments and be able to address pretty much everything in the final rule that comes out, saying we got comments on XYZ from these types of people, and this is how we're addressing it. Either we're making a change, we don't think a change is needed, whatever the case may be. So they have, quite a bit of work to do now internally. And when I was at the Department of Labor, it was a very intensive process where we are not allowed to be talking to stakeholders during that period. It's really kind of pens down pencils down, let the agency review what they've received. They will presumably, once they've gone through that exercise, they will have some summary of the comments that came in so that they can work with internally as they try to decide internally as an agency what the next step will be. And I would presume, at least this is how it worked when I was there. There will be coordination not only internally within EBSA and also within the Department of Labor, working with the solicitor's office, the lawyers within the Department of Labor, on any legal issues that may come up and, how those should be addressed. But also, we know from hearing from the agency previously that there was um, uh, collaboration with Treasury and with the SEC on different parts of the proposed rule that would affect those two agencies. So I'm sure that that will happen within this period that folks are looking at the comments. Eventually, assuming that the agency decides to go into a final rule, which I think is a very, very safe assumption that that is where they will go. Though there have been times in the past where an agency may decide the rule never gets past the proposed rule. They just, decide to leave it as it is. They may withdraw the proposed rule. There's lots of different things that could happen. They could, open for comment again on certain issues that came forward during the notice and comment process that they want more information on. I think with this specific rule, there is a lot of pressure to get something out, a final rule out quickly. So I do think that they will go in that direction. So once the agency has its version of a final draft, it will be sent, that final draft will be sent to the Office of Management and Budget within the White House administration for their review and approval. They'll take a look at it during that time period once it goes over to the White House. And those among us, whether you're interested parties, nerds, whatever we want to say, if you're really tracking what's happening, once that goes over to the White House, there is an opportunity for stakeholders to ask for meetings with the Office of Management and Budget while they're reviewing. So there is another opportunity to get your thoughts and your positions forward. But once that process goes through at the White House, they'll make whatever changes, have their own discussions. They then send it back to the agency with whatever, changes they're requesting, issues, questions. And then once all of that is resolved, the agency will issue a final rule. So I've, in talking with folks just, in the community, everyone seems to think that that will happen before the end of this year. So, and then they'll set what the effective date is and all of that. So there is a lot to be done within a relatively short period of
Yeah.
time. And that's not to mention that, this is an agency that was small to begin with while I was there. They have lost a lot of employees through the many different stages, since the beginning of the administration. And it's not only a head count that they've lost, but they've lost a lot of people with very deep experience on this issue, specifically on the regulatory process more generally. So I do think that it's going to be a challenge. And they also have, it's not as if this is the only thing that EBSA is
Right.
focused on. They have a lot of other regulatory and other things on their plate. So it's going to be a pretty, tough task for them. But that's, I think, what things will look like going forward.
Okay. So you touched on this a little bit, but I'm curious to get your thoughts on, where you may expect to see most of the meaningful feedback or pushback as it relates to the rule. Um,
Yeah,
just
I'm
based on your
I'm
conversations, yeah.
Yeah, I mean, and in starting to look at some of the comments that have come in because they've been coming in,
Right.
not everybody was a, wait till the last minute person, but things have been coming in over the course of the past several weeks. And there's been a lot written, people just giving their opinions in an informal way. Um, I think we're already seeing a lot of comments and reactions to the rule that are on one extreme, one side or the other, and one end of the spectrum versus the other end, and one being that this is the best rule ever. Like, thank goodness we finally are free to invest in whatever we want to invest in. This is wonderful. Thank you. Thank you. And then we have, people on the other end of the spectrum who are saying this is the worst possible thing. It's going to be the downfall of ERISA and it's horrible for participants. And I mean, expressing true, genuine concern about it. So we have that. But, I think that um, uh, the feedback and both of those positions, have their own merit and we can talk about all of them. But I think that where we're going to see the most like feedback that we're going to have to pay a lot of attention to or where, the details will get ironed out, I guess, rather than like everything should be paid attention to. But there's a lot of feedback on the investment side, or investment professional side, where folks have been saying that, these standards really don't work for certain types of investments. And so they need tweaking or they're not applicable at all. Maybe we need more details on them, or we need less details on them. We need more flexibility. So I think there's going to be a lot of technical feedback. You have to remember too that, while we have people at these various agencies who, certainly have information about how this all works and how these different types of investment works, they don't know everything. And so I think it'll be really important to look at kind of working out the details and whether these standards are in fact um, uh, written correctly, what needs to be changed, what works, what doesn't work. So I think that that is a place where we'll see some real meaningful feedback. I think that there will also be, should also be feedback from the plan sponsor, plan fiduciary community about um, whether or not what's proposed in this regulation is realistic, doable for plan sponsors of different sizes.
Right.
I think that larger plan sponsors, I'm not saying there are some basic responsibilities that every plan sponsor, no matter what size you are, need to have, but are some of the standards written in a way that makes assumptions about how each plan functions and what each plan can be doing, and how will that work going forward? It may be that at the end of the day, the department says, well, it doesn't matter what size you are. We can't really reduce your obligations or what you should be doing. And if you are a smaller plan, then that is one thing to take into consideration. If you are that, maybe certain plans just don't have the resources to be able to consider certain types of investments. But so I think that that is, some feedback that the department is going to have to take into consideration. Other, real feedback and kind of pushback will, most certainly come from the participant perspective, because there's this push and pull between trying to give plan fiduciaries, plan sponsors some breathing room so that they can be able to make decisions, uh, embrace innovative products or different investment options that they do really feel are in the best interests of participants, and they're willing to do the extra homework, they're willing to do the extra work because they feel that at the end of the day it will really benefit participants. At the same time, looking at it from the side of participants, how much are their needs, protections, what they want, what they are really able to digest and understand, and I don't mean that in a demeaning way in any,
Right.
but I mean, a lot of these things are very complicated. And so, what are participants really needing and expecting from plan fiduciaries, with respect to all different kinds of investments, and where are we not, meeting those expectations right now? Where do we need to be doing more? So I'm hoping that this could really be an opportunity for a really productive exercise in thinking about, how do we approach this with respect to all investments. And, I also think it will be interesting to see whether, the department put out this proposal, and with the standards being as they are, how many plan sponsors really feel that they can offer certain types of investments, that will meet these standards. I mean, is there a crypto investment that can meet these standards? I don't know. I'm not a
Right.
crypto expert, but so I might tend to have my own views, but I'm not the person that the plan sponsor should be asking. They should
Right.
be getting professionals. So, but since that's what drove this, this whole regulation from coming to be at all, it will be, again, interesting to see what the output of it is. And is there really going to be increased investment in the
Right.
types of products that started this whole conversation? So,
Right.
yeah,
Okay. Your
lots to
comment
look forward
about the
to.
size of the plan, I think is really interesting because, we work generally with larger DC plans, but the majority of DC plans out there are actually smaller plans. And there's a big section of employers that don't even work with advisors today, right? And so this could be challenging to meet those standards. And we could actually start to see a shift in how the smaller end of the market kind of approaches their DC plan.
Yeah.
Um, you had talked about, um, you know, one of the intended goals of this was also to curb litigation and encourage more innovative investments. And you touched on this as, will this actually help move the needle to be determined? But do you think that this safe harbor could have kind of an impactful, positive um, change in terms of curbing litigation, like the way it's structured and how people would rely on it, like just understanding kind of the court case process. Do you think it will actually help?
Yeah, it's I think that first of all, maybe I'm too much of an optimist, but on the whether it will make impactful change, period, like putting aside litigation, I, am hopeful that we can get to a place that people feel more comfortable about kind of what the end results are of going through, trying to obtain this safe harbor, but that it will, bring forward better decision making on investments, as a general matter. That being said, whether or not it will actually have an impactful change on litigation and what, plan sponsors have expressed as concerns, I think is very questionable. Because first of all, as I said earlier, the way that the proposal is drafted, what do you get at the end of the day?
Right.
You don't get, even if you do like the best job, you are a very, well-meaning, prudent, the most prudent fiduciary who ever walked the face of, ERISA earth, and you have the best people on your team, the most expert, investment advisors and counsel. You have all the right people, and you have just knocked that safe harbor out of the park. You're the model of everything. It's not as if you get a piece of paper, as I said,
Right.
that says, I have completed, I am the best plan sponsor ever. Um, so you don't get that. You have your documentation, you have hopefully, you've gone through all of this and you have your documentation of everything that you did and what you can show, anyone who might ask, whether it's a participant or a plaintiff's attorney or an agency, whatever the case may be. You have all the receipts, as they say, of what you've done. Um, you can still get sued. I mean, people can always get sued. I think it's unfair to characterize the plaintiff's bar as being, uniformly abusive, frivolous, all of this. Certainly there's bad apples in every bunch, no matter which bunch we're talking about. But I think that, the majority of people who are bringing these types of lawsuits on behalf of participants are bringing them in cases where it looks like, something went wrong and we need to check to see how we got to this place, right? And so if a complaint is filed, again, without having the magic golden ticket of being able to go to court and say, I have my get out of court card, because that doesn't exist. You're still going to have to go through that litigation.
Right.
You're still going to have to file a motion to dismiss, and whether or not the motion to dismiss will get resolved simply, based on some review of a safe harbor. I mean, the way that the court process works, there's too much for the court to look into at that motion to dismiss stage. So I think that it would be very difficult to just be able to curb litigation at an early stage with the proposal as it's written. Um, it may be that, some lawsuits that originally would have been filed won't get filed because maybe, a plan sponsor can go to, the plaintiff's attorney and say like, hey, you filed this, but, we satisfied all of these various things. And maybe the plaintiff's attorney would say, yeah, actually, we don't want to move forward with this. That could happen, but I do, this is where I am less of a optimist, in thinking that it's going to make meaningful change, as far as curbing litigation. Uh, and also, as I said previously, there have been changes in the courts as far as what type of deference courts will give to agency action, what agencies, think about various issues. And so whether or not a judge who is looking at this says, well, the Department of Labor has said that these are the various standards, and that if you do this, this is, the presumption, these are the presumptions that you get. There could be judges that think that that's great and say, okay, there's nothing more for me to see here. Or there could be judges that say, um, that doesn't really matter to me. There is not a judicial standard here that says that I cannot look into this further myself. There is just some question on agency discretion, and I, believe that I don't have to give the agency's views on this as much discretion. So I do think, again, that a lot of this remains to be seen how it will actually play out. And, it will be, interesting to see. I mean, I would think hopefully best case scenario will be that people do actually improve practices and look at these things closely and have that record of what they've done. And that, we have good results,
Right.
hopefully. But, even with the best process, you could have a bad result. But, hopefully we have good results, or we have documentation that they can show, that despite what happened, they did everything to try to avoid, that problem. And so maybe we won't have more litigation. But again, I remain slightly pessimistic on that.
So we did have a question come in, and I'll maybe just summarize the question a bit. So, and we've actually heard this from other clients as well, is that regulatory uncertainty can lead to inaction. And so, um, when there is a ping-ponging effect between administrations and the DOL's views, it can create some challenges, right? Is the potential for this, rule to be in place till the end of the Trump administration? And if we get a different administration, are we going to see a reversal? And then really putting plan sponsors kind of in limbo. And so the question is, like, how should plan sponsors be thinking about positioning themselves, you know, when there's, I guess, or is there more stability or more uncertainty coming in terms of kind of the regulatory environment? And then how should plan sponsors be kind of positioning themselves? It's a bit of a
Yeah.
complicated question, but yeah, yeah,
Yeah. No, no, no. I mean, it's a question that comes up constantly, and not only with respect to this particular regulation, for sure.
yeah.
And and it's something for me, just having spent, my entire professional career before going to the Department of Labor, working with plan sponsors. I mean, I share that frustration because with the ping-ponging back and forth, most plan sponsors are not watching the tennis match and really excited to see like
Right.
how the ping pong or the tennis ball or whatever it is going back and forth, and the drama of it all. They want no drama. They want just give me the answer. And certainly they would like for the answer perhaps to be a little bit more one way than the other, but at the end of the day, I think the plan sponsors will just deal with whatever the answer is. So, just tell me whether or not, like, you all agree, can I invest in, can I consider ESG or not? Can I invest in alternatives or not? Like, what can I do here? So, but unfortunately, that's not what's happening. And we are kind of at the mercy of thinking, I could make a decision by the time this rule gets finalized, let's say by the end of the year, and it goes into effect sometime in 2027. By the time we get to 2028, we're, starting to look at a new next presidential election. And what is that going to say? What's going to happen there? What is that person going to feel? And how could this agency change again, their views? And, as you know well better than I, um, going into investments, it's not as if, investments for a pension, for a retirement fund or a retirement plan or investment options that you're going to give to participants go into play overnight and everything is there and available. So this all takes time. And then actually seeing the results of it also takes further time. So not answering your question, but everyone is the decision is further hampered by it's not something that you're going to see immediate results on, and it's not something that you're going to necessarily see immediate consequences for either. So all that being said, I think that the best thing that fiduciaries, plan sponsors can do is to try to continue with the basic, core rules of ERISA, which are that, you have fiduciary duties. You are required to exercise a prudent process with any decision that you're making. Take this regulation, as it's in its current process, for examining how you make decisions currently on any type of investment. And remember, that this applies to all types of investments. So take this as an opportunity for, if this regulation were to become final, where do we need to be shoring up our decision making? And really not relying on it as something that is going to get you, get out of court free card,
Right, right.
or, not relying on these things that, maybe things will become easier for you, and that there, maybe some presumption. I don't know how it would all end up, but I would say the best thing for right now is to just use this as a time to look at, your policies, the professionals that you work with, and making sure you have the best team on board, and the best processes going forward so that you can be in a good position. And then, taking the standards as they are in their proposed form, to think about different types of investments that may come in. Again, I think that the more that people can look at this not as um, a lessening of, that you get to cut corners in some places, which I think most fiduciaries are really not looking to do, but that these are tools for you to look critically, to help you think about how to look critically at some of these options. So it's kind of the best that you can do right now.
And so a question came in regarding, um, for public DC plans that, look at ERISA guidance as part of their kind of overall process. I actually think you just answered the question in terms of should we be, as a public entity, should we be looking at these six factors in this process? And I think the answer is yes. This is a way to kind of reevaluate your current process, make sure that you're checking, digging in on each of these areas and making sure that the investment selection process is really robust and thorough. So to the extent that that can be helpful for a public DC plan, even though they may not be subject to a risk, I think that makes a ton of sense, right?
Yeah, no, for sure. Again, I think the part of this that is the trickiest is the relief that one gets,
Right.
with this quote unquote safe harbor.
Yeah.
Um, will the safe harbor survive to the final rule? We don't
Right.
know. What will it look like at the end? Is it truly a safe harbor? What do you get at the end? If you comply with everything from the safe harbor, what might be challenged, even if the rule is finalized, there could very well be court cases challenging certain aspects of the final rule. So I think for public plans, I would look to it as guidance as far as what you should be considering as a prudent process. I think it would be certainly less looking to it for some kind of safe harbor or some way to that you won't have to meet those obligations,
Right. Right.
if that makes sense.
Yeah, absolutely.
Yeah.
I know we are very much close to time, so I had one last question that I just wanted to ask you, and then we'll see if we can take one more audience question. But on a personal note, right? I'm really interested, what are some of the areas that you're going to be most focused on or leaning into over the next, I don't know, 12, 24 months? Um, yeah. So I'll put that out there.
Yeah, no, I appreciate it. It's a, new chapter. So I was at a law firm for almost 30 years. I'm still a lawyer, but I am no longer with a law firm. And I guess I'll just say that coming out of the Department of Labor and having, the benefit of working with plans for so long and then seeing things from a completely different perspective, and having such a unique opportunity at DOL. When I came out of that, I knew that I wanted to be able to use all of that experience, and those opportunities in a way that just best served both everyone that is within this retirement plan community, whether they be certainly the workers, participants, retirees, and their families, and also all of the people within the community that make this work. The employers, the plan sponsors, the unions, the fiduciaries, the service providers, everyone involved. So what I am trying to figure out a way to do that best and to bring like the things that I had learned that, assumptions I had or things I just didn't understand before, bring them to everyone else. And so I am, have been focused on trying to work with people who are looking for better ways to serve participants, whether it be plan sponsors, plan fiduciaries who are looking for, ways to get guidance from the Department of Labor on how to, how to achieve goals that they're looking to achieve. So, being that interface between plan sponsors and the department, on that. Working with people who are, not dealing with the department or, the administration at all, but who are service providers who are wondering, like, just how can I be better serving both the plan community and participants? And, what did you see, Lisa, from representing, plans and then being in the regulatory side. Like, what have you seen there? And it's been great to work with different people. I am working as an independent fiduciary and a professional trustee on some plans. And that is always, I think, really important to be doing, to continue to ground yourself on what it is actually like to be a fiduciary and to be the one who is responsible
Mhm.
for making these decisions, and to just remember at the end of the day who you're doing this all for. Of course, for the workers, for their families. And also for the employers and plan sponsors who are really trying to find ways to make things better. So those are a lot of the things I'm focused on, and all trying to keep it with an eye of thinking about retirement, and making it more understandable and accessible for people. Um, so yeah, trying to find opportunities there. So I
Yeah,
don't know.
that sounds very exciting.
Yeah,
That'll be
it's
very
fun.
good.
You
Yeah,
you never know what's going to come around the next corner. So
exactly, exactly.
yeah.
Well, I know we are definitely at time, a little bit beyond. And so I just want to say to our audience, thank you all for joining today's discussion and for your thoughtful questions. We didn't get to all of them, but we'll be sure to follow up. And Lisa, special thank you to you for sharing your insights, perspectives, practical takeaways. It has been an absolute pleasure working with you on this. So, as a reminder to everyone, a replay will be available and it will be shared with everyone who registered. I think you can also access it on our website. So with that, I hope everyone has a great rest of their day and week, and we'll hopefully see you soon. Thank you.
Thanks
Of
so much for having me.
course.
Take
Bye.
care. Bye bye.